there is a process for serving that complaint, for delivering that complaint to the defendant. This is often called service of process. That is the process, that word meaning the complaint documents. So if you substitute the word complaint documents for process, it is service of the complaint documents. The reason why they use process is because there are different types of documents that can fit within that category. Like a subpoena, where you're trying to command somebody to appear somewhere at a deposition, at trial, you would serve that subpoena by use of the same phraseology, service of process. This rule, this concept, is based upon a fairness doctrine, an idea that it is fair to require that the party suing properly gives those papers to the defendant and doesn't lie and say, I mailed them when they didn't come in the mail, or I delivered them when they didn't really deliver them. So the way that that process is initiated is when you take your complaint and you file it with the court, you are actually physically going down to the courthouse and paying a fee and handing it to a clerk, usually called the clerk of the court. And that clerk will then take your money, the filing fee, and the complaint, we'll stamp it and then put it in the court file and initiate a case number. And that is how your case will travel. The caption is the document that shows the title of the case. So the caption is that part on the top that says Joe Smith versus ABC Football Company. So that caption will contain the case number, and then you will know exactly how to track that case should you need to look in the court file for it. So what I've done is I have filed that complaint and now I want it delivered. Now in past times, and still in a few jurisdictions, what normally happens is that you pay a fee to the court, and the court takes the papers and gives them to a sheriff, to a duly authorized process server, to somebody who's been certified as having the capability of properly and legally delivering those papers. Those papers must be delivered in a certain way. For example, hand delivery. Generally speaking, most complaints, to be proper, need to be hand delivered by somebody with authority, whether that be a process server, somebody certified, a sheriff or police officer duly authorized to serve that, or some other similarly related person. There are certain circumstances, whether it is set forth in a contract or by a statute, where you can perform what is called substituted service, where you cannot serve the person in person for some reason. You cannot hand deliver it. They're refusing, they're hiding, there's some reason why they're not available, and so you want to make use of a substituted form that will exist and be the same, be treated by the court as the same as actually hand delivering it. The most important thing to understand about these concepts is that we're trying to find a fair mechanism to make sure that the defendant or defendants get those papers in a way that that suit is officially initiated upon them. When you file it with the court, you are announcing to the court that you want to file a suit. When you serve that document upon the defendant, now the defendant is made aware of those claims, and his or her or its clock begins to tick. There are certain requirements for both serving that complaint and responding to that complaint. When you serve that complaint, depending on your jurisdiction, you might have, for example, 120 days to serve that complaint, to actually cause that complaint to be properly delivered to the defendant. In that circumstances, I would have 120 days from the date that I file it to make sure that it gets served upon the defendant. So, once I do that, the defendant then has a certain amount of time to respond. In the federal system and in many of the state court systems, that's 20 days. You'll notice I said respond. I did not say answer. Why? The word respond has a particular meaning in the law because filing a response includes a number of things. They include answering the complaint. I admit or deny each one of the allegations. One by one, I do it. Or I may respond by saying, your lawsuit is not proper. You did not properly serve me. The lawsuit, even if it's true, doesn't state a cause of action. You can't get any relief. For example, in the football situation, let's suppose that the footballs were delivered and that you paid. And the person was suing even though the footballs had been delivered. And there was no complaints about the way in which they were delivered or what was delivered. So you might file a motion to dismiss. What am I filing? A piece of paper. We entitle a motion asking the court to throw out the case because you don't need to defend because they haven't met their burden. What is their burden? Well, their burden is to set out those allegations, those statements, those sentences in a manner which reflects a cause of action. If you look in your rules, the rules might provide that you have to have a short and plain statement that articulates the exact relief you want and tells it in a way that is legally permissible. So going back to the response framework, that idea of what a response encompasses, you therefore can either answer that complaint or file some sort of motion, a response that says, I don't need to answer the complaint because there's something defective about it. Another example, instead of a motion to dismiss, might be a motion for more definite statement. A motion for more definite statement instead says, I don't have enough information. You haven't been specific enough. You didn't state enough facts to allow me to understand exactly what you're suing me for. So in that case, I would file a motion for a more definite statement. There are other types of motions that can be filed, like a motion to strike or a motion for extension of time, which do exactly what they say. A motion to strike, I'm trying to strike certain allegations because maybe they're defamatory, or maybe they're improper, or maybe they're not to be used in this kind of action. So what I'm illustrating is that when you get a complaint, if you're the defendant, you have the ability to answer that complaint, or you have that ability to challenge that complaint. The response encompasses both of those. By doing that, you will understand fully your options when you receive a complaint.